The gap is ultimately 6th of March to the 13th, I think,
So,
which is perhaps the more important point.
yeah.
But in my submission, they won't have forgotten all this. Can I also, while I'm on this point, at 4738, a little bit further on, is the point about prejudice. And this, 4738 to 4741, he goes on about prejudice. Ignore all prejudice. Just look at the evidence. Don't speculate. And it goes on to 4741. In 4741, halfway down the page. If I can just ask you again to read that yourselves. In particular, the first half of 4741. Again, I implore you not to allow feelings of sympathy or prejudice to influence you, cause you to ground your verdict. There's no room for a verdict which has its genesis in sympathy or prejudice. Your verdict must be arrived at on the basis of the evidence and on that basis alone. All this is coming quite early on in the summing up, but it's absolutely emphatic. And just while I'm on the summing up, 4769 is where the judge gives his direction, or the first of his directions, 4769 to 4770, to keep separate, that is to say, consider each of these cases separate. It's an important direction in the context of this type of case. Now, in my submission, taken in the round, these directions were good enough to ensure that the 10 jurors at least who returned the verdict of guilty did so uninfluenced by the offer, or by the misconduct, rather, of the bribing juror. They would not, in my submission in the light of this, have said, or been subconsciously influenced against them. These couldn't be firmer. That leads me to my fourth point. Was there, looking at the case as a whole, a real risk that the trial was unfair? It's a slightly different question, but it's a global question. I say no. First, I say...
Just before you go there,
yes, of course.
Could I trouble you just to take us to what was said by the judge immediately after the hearing in chambers? You took us to it yesterday, just in terms of page reference.
Forgive me, my lord.
5149.
I'm very grateful.
Yes.
Now,
5149.
514.
5149 lines 4 to 13.
Yes, thank you.
thank you.
This was after the
Immediately after.
immediately after the matter had been raised with the judge.
Yeah. So the jury come back in, so to speak, after the half hour when they've been kept waiting. And this is the first thing the judge says.
Sure.
And that's why we say it's obvious to the jury what he's referring to, because they will know what has happened in the previous half hour.
Are you suggesting that's a targeted direction? It might be said against you. He's just repeating what he said right at the start of the trial. He's had a specific allegation made, and all he's done is to repeat what he said to the jury at the start of the trial.
Well, without adding quite a bit of the stuff he did say at the start of the trial, summing up. That is true, my lord. I fully accept it is not targeted. The question is overall. The overall question is, did the jury, is there a real risk the jury was influenced? against the appellants? I submit no. They've got the message from the judge loud and clear all the way through.
Do we see anything in either the judge's appraisal of the problem or in the Court of Appeal's appraisal of the problem of a real weighing of the risk of what I think counsel for the defendants at the time called overcompensation, i.e. a risk that because there had been a widespread attempt to bribe the jury, then the defendants must be guilty?
My lords, I think it's fair to say there is no... well, the judge himself, obviously, he doesn't, because
He's obviously heard the
split
submission.
decision. Yes, no, he doesn't. No. He just goes ahead. It's a fairly short... The trouble is, it's all dealt with very quickly. It's just
The
a
Court
short...
of Appeal don't seem to address their minds to that issue.
Not quite clear to what extent that was...
As you've shown us at any rate.
One of the problems is in the Court of Appeal, as far as one can tell, that doesn't really appear to be the main thrust of the appeal. The thrust of the appeal was more investigation should be made by the judge. The bias point, it was there, but it wasn't, so to speak, centre stage. That's my understanding. And so that, no doubt, is why the matter doesn't receive the attention which now it's been subjected to. But, my lord, the next question is, if I may, was there a real risk that the trial was unfair? I submit that is the ultimate question. That is to say, unfair by reason of subconscious prejudice, conscious prejudice against the accused because of the bribes that have been offered, apparently in their interest. I say there is no real risk that the 10 jurors who voted to convict were influenced to do so by their knowledge that bribes have been offered by the miscreant juror. And first of all, can I just make this point? I submit it as more accurate to describe the question as one of prejudice than as one of bias. The reason I say that is this. Bias generally, in general language, arises as a result of an internal disposition which affects a person's whole way of thinking about a case or about a matter. And this, in my submission, is a heightened, and therefore there's a heightened risk that a juror won't comply with his oath. Supposing I'm an absolute out-and-out racist, I believe all black people are useless or bad. Well, you're never going to get rid of that. The problem is you're very likely, it's just me, it's part of me. Or let us say I'm a Chelsea fan and I'm a referee in a Chelsea game. I'm just going to give all those split decisions to Chelsea and so forth. It's just in me. I can't help it. That's, in my submission, bias which is irremediable. But there's, at the other end of the spectrum, there's prejudice which arises as a result of, or potential prejudice, which arises in the mind of a neutral person, or neutral jurors, which comes about as a result of an external event, such as here. Or it could be, let's say in the course of a trial, knowledge of bad character comes out. It's that that's the real analogy we have in this case. The jurors have found out something which could weigh against which could cause them to weigh or take things into account against the accused and make him think that he is guilty when otherwise they would not have come to that conclusion. And in my submission, it's that type of case we're dealing with. Was what happened something which is likely, or there's a risk that it caused them to come to a conclusion they would not otherwise have come?
Does it make a difference whether it's bias or prejudice?
It may not, but
I can't see what difference it does make at the moment.
But there are some types of prejudice which are more deep, if I can put it this way, insidious. And that would be a racial bias than, for instance, I'm a neutral person and I've come to find out something in the course of a trial, and it will be easier, in my submission, for me to forget. And the court can more easily assume that the jury will comply with their oath.
So do we come back to Lord Justice Bingham's, as he then was, test in Putnam, where
Yes.
there's a real risk that, not on this occasion a single juror, but all of the jurors, or one of them, might, as a result of the approach, consciously or unconsciously, have become prejudiced
Yes.
for or against
Yes.
one or more of the defendants?
Yes, I accept that as the test. And that, in fact, the way it's put there is prejudice rather than bias. My lords, I accept that is the test. But, as against that, you have to start from the premise that jurors, you can trust jurors not to be prejudiced and to follow their oath. And I've given you the reference in Bonnet. I won't take you to it now because I'm conscious of time, but also at this point, a similar point arose in the case of Morrison, which you can see at E7560, in particular in paragraph 19. We refer to this in our case, and then 7565, paras 40 to 41, 42, and 44 to 45.
So it's
7565, 40, I think, putting it more simply, 40 to 45. And that was a case where, again, the Court of Appeal said, well, you must trust the jury to perform their oath in accordance with their duty. It's a fundamental tenet. Now,
Mr. Knox, I should let you know that we've now received the correct version of the Jury Act, and the version of Section 31 that was enforced then is much simpler, and I think it all makes sense.
Oh, I'm sorry it didn't make sense.
Well, it's rather easier to make sense of it.
But I'm grateful, my Lord. I haven't yet seen it, but my Lord, I'm conscious of the time. Can I just I move on to my next point? The first point I'm making is you can trust the jurors. This was a question of prejudice, external prejudice. You can trust the jurors to obey their oath. That's my first point. The second point is this. For the purpose of deciding whether the jurors have complied with their oath, you look at the case as a whole. And especially two things. The overall strength of the case, because that goes to whether they would take any notice at all of the offers of a bribe, and secondly, the actual verdicts they came up with. If I can deal with the second point first, the verdicts. As I mentioned, Shane Williams was acquitted. The evidence against him was less strong. It was simply that he was identified by Chow as one of the men in a video talking about, or appearing to talk about, a killing. The case in which this point is made that you can take into account, or it's a point that matters, is the case of Sander, which is an ECHR case at 7965. I won't take you to it, but it's in the dissenting judgment of Sir Nicholas Bratzer. I think it was 4-3, but he makes the point that the Court of Appeal in England had found it a significant point that there were two Asians, one of whom was acquitted, one of whom was convicted. And that was a significant point in showing that the alleged racial bias didn't actually make much difference, or was unlikely to have made any difference to the jury's thinking. And likewise, I say, by parallel reasoning, here too, the bias, if you've expected the bias at least to be operative, or you would have expected Shane Williams to be convicted as well, but he wasn't. As to the strength of the case, if I can summarise it briefly, just take you to one or two passages. Prosecution evidence fell into 5 categories. First, there was Chow's evidence. That is summarised in the Court of Appeal's judgment at 5778 paragraph 9 to 5779 paragraph 12. In short, he goes along with the deceased, he's taken along with the deceased in the car with Campbell at the front, driven along, and then he says, because they're being summoned because the guns have gone missing, and then he witnesses the killing by the 4 appellants at the relevant premises, those premises being owned by Mr. Palmer. After that, he returns and he takes Mr. Palmer to hospital. After that, he is offered, they try to get him, Chow, to leave the country along with them, a few days after. That's the thrust of his evidence. Now, that was obviously evidence subject to a lot of challenge, but the real point about it is it was supported by all the technical evidence. It was supported by the technical evidence, the phone calls and so forth. Well, that was one category. The second category was the deceased's girlfriend's evidence, to the effect that the deceased was never seen after the 16th of August 2011, the inference being he was obviously killed on that day, as Chow said. The third category was the evidence of the police investigations after the killing, and in particular, the entire interior of the house where the killing took place was burnt on the 27th of August, about 2 weeks later. There was a foul odour there on the 29th of August, query what was going on, and then by the 30th of September, the entire rear of the house had been demolished. And that is, you get that at the Court of Appeal's judgment, 5780 paras 14 to 578117. And the appellants were arrested on the 30th of September 2011, and that's 578118. And the point about the burning of the houses is that this was Palmer's house, and there was no report of any damage being done to the house at all by Palmer, and that was a point that was made to the jury. How come, if he owns the house and it's been damaged or burnt down, or burnt at least, how come he makes no report of it at all? The next category of evidence was Exhibit 14C. That consisted of voice and text messages from Palmer, and they are summarised at E5803 to 5807, and they are also summarised in the SFI at E6135, para 10, to 6136, para 13. If I can just ask you briefly to look at the Court of Appeal's summary of that evidence, because it just couldn't be clearer. E5803. A big passage describing Exhibit 14C begins at paragraph 69, and then paragraph 70 describes or summarises the effect of the voice notes. In the original, they're quite difficult to follow because they're all in patois. But you can see if you read 70, paragraph 70 at 5803, on to, if I may ask you just to read yourselves to 5806, the end of 5806, you can see the nature of this evidence. And in particular, you will have seen in passing 5805, paragraph 73. This is Palmer's text a few days after the event. Between me and you, the recipient's not identified. We chop up de boy lizard, that's the deceased's nickname. Fine, and dashing we enough. As long as you live, dem can never find him. Oh, couldn't be clearer. But the whole picture couldn't be clearer. And then we have also from JS2, I'm just going to give you the references, we have the texts between the deceased and his girlfriend, in particular on the 16th of August 2011. They are summarised at E4788 to 4791. And you can also see a shorter summary at in our written case, at 6227.
Can you just give those references again?
Of course. Yep. 4788.
Yes, thank you.
4791. And in our case, they're summarised again at 6227, paras 40 to 41. But those texts show without a shadow of doubt that the deceased was on his way to be executed, and he suddenly realised what was going to happen to him. There can't be any doubt about that. There are some texts also from Palmer. They were of no significance, but there were texts from Sean Campbell which, to an extent, were incriminating, which suggested that on the day of the killing, but before the killing, Campbell said, who thief it, go dead. That's say, whoever stole it is a dead man. And then after the event. But the references, you can see those texts at 4989, lines 1 to 14. And 4990, 13 to 4991. So they're plainly incriminating. Now, the defence cases, and it's important to understand what the defence cases were, they all just gave unsworn statements. Palmer's case was simply that he had never met Lizard at the premises on the day in question. And, my lords, that is at 4341. I should emphasise this. The SFI says that Palmer says he wasn't at the premises. That wasn't actually what he said. He said, I didn't meet Palmer. I never met Lizard at the premises. Rather different. So he doesn't give an alibi. The important point is he doesn't say, oh, I was at a concert or whatever, somewhere in Kingston. No alibi. Campbell, in his unsworn statement, accepted that he drove, he says, ahead of the deceased and Chow in another car to the premises, but he says the deceased got out before getting to those premises. And when Campbell got there, when Campbell got to the premises in question, he says he left Chow there. In other words, Chow did go there, but Campbell says he then left. And later, he saw that Chow, later that evening, he said the only thing Chow mentioned was that Palmer had received a dog bite and had to be taken to hospital. That's 4383 to 4386. Jones's defence was a very short statement. He just said the police were lying about him. That's 6137 at 16, or that's the, I think, of the SFI, and in the record, 4387 to 8. And St John said he left the premises just as Chow entered, and he saw Palmer getting bitten by a dog. And that's 4390 to 4392. The short point is that there was no denial, as far as one could take out, that they were there. And that is significant because the premises are then subsequently destroyed a few days later, or partly destroyed. And there's no explanation for this. Now, as to the exhibits, X14C, Exhibit 14C and JS2, their cases were simply this. The police have fabricated them. There's just a giant conspiracy to fabricate a whole mass of evidence. And there were challenges to the chain of integrity that went to that. That was it. But there was no explanation as to why the police should have done any of this at all. Now, my lords, bearing all that in mind, we say this was an overwhelming case where, for some reason, the only real question was, were the police in some way motivated, or did they fabricate all this evidence? That was the question for the jury. And, my lords, my lady, I respectfully submit there was nothing to support that. It's difficult to see, therefore, in those circumstances, why the alleged, or rather what you might call the bribery, would have made any difference to the consideration of their verdict. And I do submit the strength of a prosecution case in circumstances like this is a material factor. When one is asking, the question is there a risk, a real risk, that the verdict was influenced by prejudice? And I say, no, there's no real risk of that. My lords, my ladies, as far as the jury retirement point is concerned, that's what we say. So we say there was a fair trial, and the fundamental point is you can be satisfied that that 10-1 verdict was a verdict given by the jurors, or the 10, in accordance with their oath, uninfluenced by bias, prejudice. And if that's right, I submit the appeal must be dismissed. The next question I can deal with very briefly is the jury retirement point. My lords, my lady, I submit the following very short points. At the time, that's in 2011, there was no established practice written in a bench book or anything like that. The matter was left to the judge's judgment as to when to send the jury out. Second, I am informed by the Director of Public Prosecutions, who was here, who will provide more detail on the point. In real life, juries never take more than about a couple of hours or so to come up with their verdicts, even after long trials. And it is unheard of for them ever to have to be sequestered in a hotel room overnight. It just doesn't happen. Thirdly, there was, in my submission, no pressure applied by the judge in his directions. This is not a case where there was something the judge said at some point which suggest to the jury, you better get on with it. Far from it. There's at no point anything which the judge says to the effect, I do want you to come back in an hour or so, or please make your minds up, and so forth. So, nothing at all. No criticism of what the judge actually says. And finally, and I submit importantly, the Court of Appeal, who know all about this, how the system works, saw nothing wrong in what had happened. And if I can give you the reference, it's E5854, paragraphs 203 to 205, where they describe, where they go through some of the cases about sending juries out in different jurisdictions, and then again at 209, where they come up with... 5854. Paragraphs 203 to 205, where they discuss the background and various other cases, and 209. And they discuss one or two Privy Council cases where juries have been sent out actually rather later, but although the Privy Council has disapproved of that, nonetheless the convictions were upheld. But in my submission, the Court of Appeal was perfectly entitled to come up with the conclusion they did. No error of law has been identified in anything the Court of Appeal said, and I submit that it's not right, it's not the board's place to interfere with the Court of Appeal's judgment on these matters. Very briefly, the proviso, in one sense, my point on the proviso is this. Even if, let us say, the judge's directions after the jury incident were not as strong as they could have been, or should have been, or even if the retirement was too late in the day, there is still no reason to suspect that the jury was infected by bias or the risk of bias, given all the matters I have said. That being so, even if there was some irregularity or some imperfection in the way the trial was conducted, this is a case where there has been no, to use the words of the statute, no substantial miscarriage of justice. I should emphasise that I accept that if there was a risk of bias, a real risk of bias in the verdict, that would mean the trial was unfair, and that would also mean that you couldn't apply the proviso. An unfair trial is written water. But if the trial was fair, in my submission, you apply the proviso.
Do we have the statutory provision that contains the proviso?
I think we do. In the bundle. For some reason, I seem to remember reading it recently. If I'm wrong, I'll be corrected. Perhaps I can...
Perhaps you could have the reference later.
I'll give you the references if I can
Thank you very much.
My lord, my lords, my lady, that is only one point.
Yes, I think it's page 6806.
Thank you.
I think it's in the standard form of wording you're probably familiar with from other jurisdictions.
Well, I have noticed that they vary on
Well, the one we've been given
that's why I asked.
is the Judicature Appellate Jurisdiction Act, and it's section 14, the proviso to section 14.1.
Thank you.
No substantial miscarriage of justice test.
Yes.
And that's why I say there is, subject to the unfair trial point, subject to the unfair trial point, there's no unfair trial, the proviso I submit applies. The final question is that of remission. In my submission, this could hardly be a more serious case. It is of particular concern that we are talking here about great celebrities. That doesn't mean that you apply a different standard, but of course it does mean, in my respectful submission, such a high-profile case with, on the face of it, such overwhelming evidence. Most of it, of course, not the entirety of it, being of a technical nature and so forth. I submit this would be an appropriate case for the matter to be remitted for a retrial. My lords, I don't think on the whole you yourselves do that. You normally send it back to the Court of Appeal to consider. But I would submit there's every reason, if I'm wrong, for the Court of Appeal to consider what to do. My lords, those are my submissions on the main point. I've only got a little bit of time on the other points. I think I'm right to say my lords, you have seen our written case.
Yeah, this is the JS2.
Yes, the JS2 point.
Want to hear about it? Or do you want to go off the bench?
Should we write this for a moment?
Yes. Mr. Knox, we'll rise for a moment or two just to consider whether we need to hear you on the JS2 point.
I'm obliged, madam.